asking unanimous consent.
Without objection, the gentleman is recognized for 5 minutes.
Madam Chair and members of the committee, I first want to correct some of these mistaken assumptions that I think Mr. Sauter just made in his remarks. He claims that the language of Section 8A3 would undermine the definition of marriage that some states have chosen to adopt. This is untrue. Even after ENDA becomes law, regardless of whether Section 8A3 remains in the bill or is taken out, the states, for purposes of state law, decide marriage issues for themselves. Nothing in ENDA would change that. Nothing in ENDA would alter the federal laws referred to in the Defense of Marriage Act. Second, Mr. Sauter makes the claim that Section 8A3 would have prevented an employer from firing an employee who has an extramarital sex. Frankly, I don't see anything in the text of 8A3 that discusses extramarital sex. In fact, I don't see anything anywhere in the text of ENDA that discusses extramarital sex, and I can't understand how Mr. Sauter has come to this conclusion about extramarital sex. But the entire issue is just a diversion from what ENDA actually does. ENDA is very simple. ENDA will prevent employers from firing a perfectly qualified gay, lesbian, or bisexual employee just because that employee's sexual orientation. Mr. Speaker, in short, I will vote for this amendment, but the fact of the matter is I don't think it is necessary. But Mr. Sauter has pursued this course, and I think that it's important. Another important provision of ENDA is the non-discrimination section that already outlaws employers from discriminating based upon sexual orientation through any pretext policy, including the pretext of marital status. Moreover, many states, including Mr. Sauter's home state in Indiana, have already created state laws that allow a plaintiff to sue their employer based upon marital status discrimination, and those state laws will further protect against pretextual discrimination against gay and lesbian Americans. Finally, I want to explain in more detail why I will vote for Mr. Sauter's amendment. I have realized that Section 8A3 is redundant. It is unnecessary. The concern of Section 8A3 is sought to address and will actually be addressed in many cases by Section 4 of ENDA. Let me explain this concern. When Mr. Frank and other original ENDA sponsors and I wrote this bill, we were worried that a clever discriminatory employee might realize he could not fire a gay employee specifically because of his or her sexual orientation. So the discriminatory employee might decide to create a pretextual reason for firing that person. In this case, the fact that the employee is not married or does not have the right to get married, that's why we drafted Section 8A3. However, the thing that convinced me to vote for the Sauter amendment is the fact that in Section 4 of ENDA, which my committee marked up in favor of the report, it makes the Sauter amendment practically irrelevant. Section 4 of ENDA is the portion of the bill that will very clearly prohibit the discrimination based upon sexual orientation. So if an employer is actually discriminating based upon sexual orientation but is pretending that the decision is based upon marital status, the gay plaintiff will have the opportunity to convince a federal jury of that fact. Consider the following example. A large accounting firm that has no policy whatsoever about whether its accountants should be single or married. That's not hard to picture because not many accounting firms anywhere in America has a policy that requires an accountant to be married. Many being a good accountant is the reason that they hired people. Then imagine that one of the accountants on a branch office lets his coworkers be as gay. Now say that the branch office is a homophobic manager who at the very next day a memo announcing a new policy in the branch office that all accountants will have to be married to keep their job. The manager has figured out this new policy will allow him to fire gay or lesbian accountants, and what happens only to an accountant who is unmarried. Also imagine that after sending out the memo, the homophobic branch manager sends an email to some of his colleagues explaining, now that we have our new marriage policy, we can fire that disgusting homosexual accountant. That gay accountant will be able to file a lawsuit pursuant to ENDA, and that's the point of this legislation. They will be able to put evidence before a federal jury and to try and convince them that it was really fired because of sexual orientation, not because of marriage policy. And that is why this legislation exists. My point of the scenario is that what I've just described to you is that already covered by Section 4 of ENDA, stating that the same thing of Section 8A3 is just redundant. For all of these reasons, I will vote for the amendment offered by Mr. Sauter. Even if 8A3 is stricken from ENDA, I believe that the gay plaintiff will still be able to succeed in court and have a meritorious claim. And I reserve the balance of my time.
The gentleman reserves his time. The gentleman from Indiana.